I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes.
That's true.
Okay.
We're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge. So just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out.
All right, pause right here. This is where things get legally spicy. The defense isn't arguing innocence yet. They're attacking the evidence itself. Specifically, whether the breath test should even be allowed in front of a jury. If this gets excluded, the prosecution just lost one of its biggest weapons.
Basically, because the officer gave language that was outside the statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the.
This is a huge problem, legally. Police are required to read very specific statutory warnings. They're not allowed to sweet-talk suspects into compliance. If a defendant is led to believe, blow under the limit and you're free, that consent may not be voluntary at all. And voluntary consent is everything here.
The fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, and based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing.
And if you're not ready yet, it's okay, because I know that we're kind
I was
of.
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support.
Translation for everyone at home. Even if the law is messy, appellate courts usually defer to the trial judge. That's called abuse of discretion. So whatever this judge decides, it's very likely to stick. The pressure is on, and everyone in this courtroom knows it.
The fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals. And there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion. And the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the conclusion.
Let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not been
seen-
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home. Which is like dangling candy in front of a baby,
That analogy wasn't accidental. Defense counsel is painting the officer as someone who crossed from informing into persuading. The law allows information. It does not allow incentives.
Is there
And juries and judges tend to hate shortcuts that smell like coercion.
Is there a case that says, hey,
And that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail, and it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be.
This is courtroom chess. The judge wants efficiency, but there's a risk here. Pick a jury before ruling on the breath test, and suddenly both sides are arguing blind. One wrong move, you've got grounds for appeal.
We have a panel here ready to go. So I don't want to keep them waiting. They've already been waiting for, 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this.
Well,
Right after
the only thing that
I don't want to keep them waiting.
no, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that there is no breath
Of
test.
course.
So I think
I guess we're ready to roll. But and then we can
I
enforce.
just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can,
Sure.
and then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the two outstanding case law that we have.
For sure. Okay. Number one, is that spelled correctly? There's usually a Y-E-N.
That's what I was thinking too, but that's what they put in the confirmation too, I think, so.
What would do you want something?
Yes, Judge, we wanted a bond on him, I believe, it's a 1997 warrant, so I'm a bit.
He's here if we want to bring
He is
him
in the
up.
back.
Please.
So, I did want to see, I asked him to agree on the bond, they are not because of his criminal history. He's got criminal history that dates 20 years back. I don't believe he's got anything current as of 10 years. So this is a warrant out of New York.
Yes.
30-year-old warrant, so.
He's literally he's been on that. The warrant is truly 30 years old. Really? Is that old?
1997.
Yes, Judge.
What,
Bit confirmation on it would be great.
from him?
No, from I believe. Prosecutors have something.
Wow. So it's a burglary, it's an assault, it's a robbery, and a possession of a weapon. Okay, I guess let's talk to him when he comes out, you know?
1997 New York, Judge.
Is that what was happening in 97? I thought New York was dangerous, but shit. Do you want to do a name change, Katie, or no?
I don't want to.
For the fugitive case, Judge?
No.
This is spelled Nguyn, and there's always an E.
I don't think we would need one for the fugitive case.
Okay, I don't know.
I can look at the warrant and double check.
Good morning, Ms. Nguyen.
Good morning, sir.
Mr. Nguyen, you're wanted out of the state of New York for a host of charges, specifically for a burglary, an assault, a robbery, and a possession of a weapon.
He did do parole. He was out on parole about 10 years ago on these cases. So once again, we're not sure.
Wait. That may change things. If he's out on parole,
Can I
then,
say something?
hold on.
I'm sorry.
It's okay. But if he's out on parole, Katie, there may be a pre-signed waiver.
He completed parole.
Judge, let me check. I'm not seeing that we have a pre-signed waiver,
Have you?
but I think that, Amy, you had some contact with the jurisdiction?
Yeah, so Manhattan County reached out to us this morning. They were asking if we had the waiver or a refusal for him yet. They didn't indicate to me whether this was a probation or a parole. I can reach back out to them to see. Yeah.
That's really important.
I'll do that.
He couldn't have completed because there's a warrant. There would be no warrant if he completed parole.
In as much as.
Something must have happened, Mr. Nguyen.
Can I say something now?
But don't talk about the case in general, but just,
Can I say something?
there's a warrant for a reason.
Can I say something?
Of course.
I used to live in Brooklyn. I committed crime and I lose, when I'm 16, 17, I don't speak English that much. So they send to me, whatever they send to me, they send me to Rock Island and they send me to upstate. And the judge say like, burglary, on robbery, some kind of stuff like that. But I do not speak English that much at that time because I came United States when I'm 14 and 5 years later I got arrested. So I basically understand a little bit, not that much. So when I go to court, they just do whatever they want to do. They don't tell me nothing. The case, they just say you got arrested, you got robbery, burglary, something like that. But I do not understand like that right now. So basically, after I finished, after they tell me that, they send me Rock Island. Or Rock Island, they send me upstate. So I do 5 years. First, I do 5 years.
Okay.
And I see parole.
Okay.
Parole, keep it 2 more years. And I finished 7 years, and I went home. And then I went home. I do first. I went to live in Long Island first, and then I still go see parole in New York. Right, and then my parents live in Houston, Texas, so I asked for transfer, my paper in transfer to Houston.
Okay.
So I've complete my parole, everything, and the opening.
What year?
No. So you may have tried to transfer it. Perhaps it never transferred and you just came down here and never
No.
finished the transfer. I don't know.
No, I'm not the people do for me. That's why I'm allowed to transfer to.
Yeah,
Maybe there's an issue with.
there has to be some kind of issue.
Yeah, that's what I'm saying.
I don't think we have enough information to do anything right now. What I need for them to do is reach out back to New York to figure out why the warrant was issued. Is it a parole violation?
I got parole violation one time. I went home, I worked, and I got violation one time. I went to work and they picked me up what's that? Angleton. I went back over there and I stand right in front of the judge. The judge said, "What you do? Why you don't parole?" I said, "I'm working." So he said, "So show me your work." So I work. I bring all my paper, tab paper. I showed him. So he's still on parole. No. Can I say something? Yeah. Go ahead. He sent me to immigration. Immigration. They're coming out. I still do parole. I still finish. I have the letter over there.
Let's do this. Let's do this.
Yeah.
I'd like to roll it.
But no, that's true story. That's true story.
No, I get you. We just need them to.
So let's do this.
Yes, sir.
I'm going to roll it to tomorrow because it's already nearly 12 o'clock. I want to give them time to look into it, to see what New York has to say. A lot of times when you get on parole, you sign a document that's a pre-signed waiver, meaning that you already agree to waive extradition if this happens. We need to.
And just like that, the case takes a hard left turn. A 30-year-old New York warrant enters the chat. If there's a pre-signed extradition waiver, the judge's hands are tied. No bond, no discretion, no sympathy. This isn't about guilt anymore. It's about paperwork signed decades ago.
Know if that has happened and if you have signed that, because if you have, I cannot give you a bond. Even if I wanted to give you a bond, I cannot give you one because there's a waiver that's already been signed.
What does that mean, waive, sir?
I'll let Ms. Oko explain that to you in back because I got a lot of people waiting.
Yes, sir.
But regardless, I'm not ready to do anything today.
Yes, sir.
I need more information from the prosecutors.
Can I say last thing before I go?
Sure.
What I do is, what happened is I finish parole, everything. I get the letter from Albany, say I'm complete. Albany State in New York. That all the paper go to Albany.
So, but something must have happened.
We need to figure it out.
Yes, I got the letter. They send me a letter. Everything.
And Judge, I would just add that, I mean, at least from what I'm seeing when I run him, which I'm a little hesitant, but like there's like multiple states with like criminal histories that's like very extensive. That's more than just New York. And so we would also have to try to like.
Okay, I guess just take your time, find out, and then we'll regroup tomorrow.
And all his 20 years back. There's nothing more.
I get it. I just want to know if there's a pre-signed waiver. We'll see you tomorrow.
All right, thanks, sir.
Okay, of course, Mr. Wayne. Please.